Good morning, ladies and gentlemen. My name is Raymond Koskie, and on behalf of myself and Warren Winkler, seated to my far right, we are your co-chairman for the Law Society's annual program on labor relations, which is a continuing education program. And as part of the Law Society's attempt to bring the public closer to the legal profession, our program has been one of the first ones which is open to the general public, and because it met with success some years ago, the concept has been repeated every year, and we hope for many years to come. Our past programs in the past 10 years or so have each dealt with a specific area of labor law, and as the material indicates this year, we are going to be talking about recent developments in labor law, and in particular legislative, administrative, and the judicial aspects of labor relations in Ontario, with emphasis on the industrial and construction industry labor relations. And as usual, Warren Winkler and I are extremely pleased with what has now become the traditional cooperation of the labor law firms in Ontario, without whose assistance these programs cannot be put on. When one considers the small number of labor law firms in Ontario and the fact that we have over 24 people helping us in this program, including the chairman of the Labor Relations Board, one begins to have some concern as to the uncontrolled labor wars which are being raged today while everybody is here. And we are all here today trying to cultivate our knowledge of labor law. Now, speaking of knowledge of labor law, very few of us are probably unaware that the labor relations community is very much in debt to the often inept management of the Toronto Argonaut football team. And the reason for that is that in 1967, the Toronto Argo football team failed to capitalize on one of their third draft choices, namely our guest speaker this morning, George Adams. Mr. Adams was a third draft choice in 1967, but obviously that career did not last too long, and he went on to become one of the foremost labor law academics in Canada, which eventually led to his becoming the present chairman of the Ontario Labor Relations Board in 1979, where he displayed his rather innovative prowess in the area of granting remedial relief under the Ontario Labor Relations Act. So much so that it is not uncommon for people to overhear in various conversations, quotes, "Leave it to George, he'll find the remedy," end of quotes. And of course, this has led to a certain amount of criticism of our guest speaker, none of which is justified, of course. His curriculum vitae is extensive, with experience in all segments of labor relations, including what has sometimes been regarded as the bastard of labor relations, the construction industry. In addition, our guest speaker has written, taught, and arbitrated extensively, leaving no doubt about his credentials in this field. And therefore, it gives me great pleasure to introduce our guest speaker, Mr. George Adams, Chairman of the Ontario Labor Relations Board.
Thanks, Ray. I think Ray was kind of digging far into my past with that Toronto Argonaut football story. I was wondering whether he'd get into a few foot races that I won when I was a small child in grade school. You can tell who is hungry and who isn't by the fact that this seminar, one that relates to collective bargaining, is being held on a work day. I attended a seminar on wrongful dismissal with a good number of you on last Saturday, and I take it that they held it on Saturday so that there wouldn't be a billable hour missing. And there was a cast of thousands present, as many of you will recall, no doubt drawn by Mr. Justice Robbins, who presented a keynote address. His lordship, as evidence of his great powers as a jurist and advocate, began by serving a loaf of bread and a few fish to the many of us sitting out on small mounds beside the City Hall, listening over a loudspeaker. For his next act, and one just as magnificent, you'll recall he summarized the law of master and servant in about 25 minutes and rendered the rest of the day and the speakers redundant. And moreover, he did this with a self-effacing caveat that these were mere comments and not a full-scale keynote address. You can see the ingenuity of Koskie and Winkler in today's program in describing what I'm to give you as the theme address, an imaginative variation on the keynote address, I take it. And the unfortunate fact is, though, that I'm a little more human than his lordship. But to add to my own frailties, I wasn't given much in the way of advice from Messrs. Koskie and Winkler again. Warren asked me to do it and told me to confine the speech to recent developments in labor law, in effect to try and tie together the disarray reflected in your program. Koskie, on the other hand, learning of this direction, totally and fundamentally disagreed and directed that I speak on anything I wish. Again, more useful help from Warren and Ray. Warren hoping that I hang myself and Ray really not caring. So you can understand why I was immobilized only until this morning when I began to sketch the outline to this talk, and it looks pretty good at this point, and we'll push on. But what I thought I'd do is talk about a few things that I decided not to talk about, just to lay the background to what I'm about to say. And the one thing that I decided not to talk about was a recent recommendation by a fairly prominent practitioner before the Labor Relations Board that to be a vice chairman, alternate chairman, or a chairman of the Ontario Labor Relations Board, you ought to meet the qualifications of a Supreme Court jurist. A recommendation probably reflecting the importance of the tribunal in labor relations today, but one which has a number of arguable implications and raises the possible problem of finding no one so qualified willing to serve. So I rejected the idea of discussing that on the basis that it would involve a highly self-serving defense. But I thought, just by way of prelude again, and to give some time to the thousands that are going to join us, I thought it would be interesting for you to know that the government has been very selective in the people it has appointed to the Labor Relations Board, and indeed in recent years has developed a highly sophisticated questionnaire, Warren, aimed at isolating those who are completely suited to labor relations adjudication. And what I thought I'd do, I just run briefly through a few questions out of the questionnaire that I successfully completed. And this will reassure all of you. The first question, this really wasn't the first question, it was down in the questionnaire. Question 1, on a lazy Sunday afternoon, I most enjoy, and then there's a series of choices. You've filled out these questionnaires before, no doubt. Cooking, experimenting with makeup, going to the museum, just lounging around the house, exiling people. And then you mark one. So you guess which one I marked out. Second question. I think people look best in A, formal attire, B, bathing suits, C, clothes that reflect their lifestyle, Bermuda shorts, prison uniforms. The proper manner in which to respond to a chance meeting with me is by, all these questionnaires are compiled by key psychologists and psychiatrists in the field. Smiling, nodding, saying hello, giving me a little kiss, saluting. On a date, I most enjoy A, an art film, B, bowling, C, dinner in the theater, D, ruling. I won't. I'll just do one more, and then because I think you can see just how selective these questionnaires are. Last one. My friends call me A, Stretch, B, Doc, C, Tony, D, Izzy, or E, Supreme Pontiff. Now, the board has put in place a highly sophisticated staff development program, orchestrated by our manager of program development, Eleanor Meslin, and aimed at keeping everyone sharp, much like this program. And at a recent seminar, we were briefed by eminent experts on economic theory, and the topics included a systematic application and critical evaluation of the basic analytic concepts of economic theory with an emphasis on money and why it is good. We looked at fixed coefficient production functions, cost and supply curves, non-convexity. I had trouble at the seminar with that word. They were all discussed, as well as spending, making change, keeping a neat wallet. Other topics included inflation, depression, how to dress for each, loans, interest, and welching. So I think it's clear that you're served by a highly qualified, capable board. With that background, I'll get into more of the substance of what I have to say. Government intervention for the purposes of settling labor management disputes in Canada has now existed for more than 80 years, since the Federal Conciliation Act of 1900. From that moment on, there has been a gradual but steady increase in third-party regulation of the collective bargaining process. The result of these additions to the process has been the growth of a considerable body of law governing the behavior of management and trade unions in dealing with each other. This body of law may be regarded as distinctively Canadian in that it contains several features not usually found in other industrial countries. Its most prominent characteristic, and one that continues to saturate the recent changes you will discuss today, and that is a high degree of compulsion. But I think it's important to emphasize that in the development of labor law policy, such compulsion has always been in the name of industrial peace, and the schemes put in place, as well as their application by the Ontario Labour Relations Board, are very much influenced by another important labor law goal, freedom of contract or self-regulation. We, and I mean legislatures and bureaucrats or administrators, must all keep in mind that the system is driven by the reality of economic power, and that at any point in time the power relationship between labor and management may not be equal. Accordingly, while compulsion appears to be on the policy ascendance, legislators and administrators cannot lose sight of the fact that collective bargaining is essentially a process by which the parties tailor solutions to their own particular needs. This is its principal strength. The rest of the day will be devoted to a detailed review of the cases and recent legislation. I will therefore be very superficial, as is my wont, and I hope brief. But throughout the day, I would ask you to ask yourself, what alternative did the Labor Board have or the legislature have when it adopted the policy that it did? Was there a realistic freedom of contract or private initiative approach to the issue that either of us addressed our attention to? And there's essentially three areas where one can look at recent developments from these two conflicting policy approaches: certification and recognition generally, negotiation of a collective agreement, and contract administration. And I'll say a little bit about each one of these three areas in terms of recent developments. And what I did, I simply took the last year of monthly reports of the OLRB and drifted through them and tried to isolate a few highlights. I'm always worried when one does that, in that you have a tendency to select your own cases because those are the only ones you've read, and even those you're a little foggy on what they stand for. But you end up insulting colleagues who probably have written more lucid, more articulate, and more sensible things, and so I apologize to my colleagues at the outset. But looking at the recent cases over the last year, a number of developments are apparent. And one area that is perplexing and continues to plague us and plague you is the meaning of, for example, dependent contractor in the context of persons providing services to more than one purchaser over a fixed period of time. And the two cases I have in mind are Corriedale and Craftwood, and the applicant in each case, I think, was the gypsum workers. And they're found in the board's monthly report for November. And in these two cases, we see the dependent contractor section being tested in a situation where persons who own their own trucks, one person, one truck, provide haulage services to many contractors in generally the sewer and water main and road building sectors. However, they provide these services both to unorganized and organized contractors in that activity, those activities, and indeed they do a little snow removal as well. The evidence revealed that the individual operators earned upwards to $40,000 a year and worked for as many as 15 to 20 contractors during that period. And in the two applications before the board, only 2 or 3% of the total income emanated from the respondent companies. However, the argument on the part of the union was that the owner-operators were no different than other employees employed on a casual basis. Indeed, the trade union emphasized the mobile nature of the construction industry, where these applications tended to emanate from, and the short-term work assignments confronting these owner-operators was argued to be really the reality confronting any person conventionally employed in that industry, a few days. The application, in effect, was based on a theory of economic dependency upon an industry as opposed to a particular employer. That really was almost an alternative approach. The board rejected the application, tossed both applications, unconvinced that these persons could be simply analogized to casual labor, or that the cyclical nature of the construction industry with its impact on construction industry employers was of important assistance to us. What we did is we looked to the truck drivers that were regularly employed by these contractors, and they weren't employed on a 1 or a 2 or a 3 day basis or on a cyclical basis. They were employed on a full-time basis. Those trucks were owned by the contractors, and obviously they're going to keep that kind of equipment in operation. And we thought that was the more relevant comparison. However, importantly, the board did not reject the possibility of a person being dependent on more than one purchaser of services at any particular point in time. But in the cases before the board, it simply could not be said that these owner-operators were dependent in any way on the two respondents subject to the application. And we have continued to be confronted with occupational groups that I would say are on the margin of the statute, looking for collective action and looking for the legitimacy of that collective action through the Ontario Labour Relations Act. And you can drift through the statutes, and in the monthly reports, I won't do it here, and you'll see recent cases with the owner-operators or an agribusiness context, people working in a really almost a factory-like setting, but they're growing mushrooms or something else, and there's an agricultural exemption. How is the board going to grapple with that? Looks like a typical factory collective bargaining setting, and yet there's an agricultural exemption. Was the statute intended to exempt those kinds of people? And we have turfed those applications on the theory that it's up to the legislature to make a change in light of changing technology or changing concentration of agricultural practices on the business side. Supervisors continue to be a difficult problem for us. A number of statutes throughout Canada, as you know, have been changed to permit supervisors, non-managerial supervisors, if one understands that, to be organized. And we haven't had that kind of direction. And yet we continue to get supervisory groups coming forward, seeking collective bargaining, and causing us to painfully re-examine our approach, and our approach is one of effective recommendation, and it would appear from the cases that we're stuck on that, and that if there's going to be a change really extending collective bargaining to supervisors, no matter how justified their claims are, it's not going to come from us, it's going to come from the legislature. Some super cases in the area of the construction industry with changes like Bill 204 and Bill 73, which you'll discuss today. I see that Al Minsky and Bill McNaughton are going to talk to you. There's a key case that I draw to your attention, Colonist Homes Limited, which takes Bill 204 and Bill 73 in the certification application and applies the bill in light of the board's earlier practices. And the issue in those cases, or in the Collins Homes case, was whether you had to have, for example, employees in the ICI sector to be certified for that sector. And the reason for those that wouldn't understand why that would even be an issue, the reason that is an issue is that prior to this change, the board had never taken sectors into account. We certified for a board area, and it didn't matter what sector the employees were in. We gave a certificate for all the sectors that were in the board area. Now, with one sector being treated differently on a province-wide basis, it causes an interesting application of that principle to the amended statute. But we have stuck to our guns in that respect. And I think it's a useful review of the statute's purpose and its origin, and I recommend it to you. Your program indicates as that the morning panel is committed to discuss recent developments in the remedial area of the board's jurisdiction, and the introduction I got was as if I was a walking remedy. And I think that's unfair. I mean, there's been some change with respect to board policy in the remedial area, but I think what you've got to do is you've got to sit back and take a look at, one, where did those cases take place, and two, statistically, what's happening at the board. So there's a couple of large cases that doesn't tell you where the board's going or what is happening on a day-to-day basis. And so let me give you some background data against which to review these changes. In fiscal 70-71, the board received 1,015 applications for certification. In fiscal 79-80, the board received 1,136 applications for certification. Not a big change. It's been very level, okay, throughout the 10 years. On the other hand, in fiscal 70-71, the board disposed of 153 unfair labor practice complaints, whereas in fiscal 79-80, the number had increased to 522. So the unfair labor practices had increased almost fourfold. And what I would point out is that I think what you see is more organizing activity in low-density industries, low-density trade union industries. And this is coupled with an average bargaining unit size of about 30 employees. And I think that is really sort of a misstatement of the typical bargaining unit that we're confronted with in the private sector, because that average, that 30 employee bargaining unit average size, is really pumped up a bit as a result of a lot of public sector applications which don't have a lot of the same heat to them. They're much larger units. So in the last number of years, the Labor Board has been increasingly confronted with applications for certification, trade unions reaching out to low trade union density industries where it may well be a small owner-manager who is competing against other unorganized employers, and it is one hell of a shock to have an application for certification come in. And one may not react in a terribly rational way right off the bat. Or we are confronted with the branch plant multinational. Has a subsidiary here, is basically unorganized throughout the world, is operating in an industry which is essentially unorganized and reacts not unlike the little owner-manager. And it's those kinds of cases that have thrown up some of these problems. But what I want to emphasize is that a concerted and planned violation of the statute remains by far the exception to what we are confronted with. We do not spend our every day fashioning innovative and intrusive remedies. We don't have to. The vast majority of certifications are processed routinely in a matter of minutes. In the construction industry, this is done without a hearing, and in non-construction industry applications, more and more parties are taking advantage of our waiver of hearing program, which you can find described in a recent practice note. More significantly, even the more highly contested unfair labor practice cases. Of the 522 cases disposed of in fiscal 79-80, 334 were settled by the parties in discussions with our labor relations officers. Only 188 applications went to the board for decision. Of those 188 cases, and now the following statistics I'll give you are notwithstanding that in non-Section 14 complaints there's a reverse onus on the employer. Notwithstanding that, relief was granted in the 188 cases only 47 times, 100 cases were dismissed, 37 withdrawn, and 4 adjourned sine die. So what I don't want you to take away from this meeting is that what you're confronted with is a board with a driving, single-minded purpose. I think you've got to sit back and you've got to take a look at the Ontario Labor Relations Board and not get too immobilized by particular cases. In the certification unfair labor practice context, then, developments include, I think it's important to discuss them, and they tend to be kind of numerous, the awarding of a bargaining certificate under Section 7A, despite the absence of membership support in excess of 45% of those employed in the bargaining unit at the date of application. And I refer you to the recent Skyline case. The award of a number of the following remedies, together with a 7A certificate, to put the union in the position for bargaining that it would have been in had there been no violation of the statute. And I say, take a look at Kmart, see the Skyline case again. The posting of unfair labor practice employee notices and the rationale for that. See the Valdi decision. Positive directions to pay a trade union for wasted organizing costs, both costs already expended and those that will have to be expended in the future, as in the recent Westinghouse case. Positive directions providing a trade union with access to bargaining unit employees during company time and on company premises in order to counteract earlier flagrant unfair labor practices by the employer. See Westinghouse, Photomat, Kmart, and the awarding of interest on back pay and other monetary awards in the Hallowell decision. But I say to you, as you look at each one of those cases, what realistic alternative did the Labor Board have as it fashioned those remedies? Our position is substantive rights acquire validity only insofar as they are backed by effective remedies. In all of these instances, the Board is demonstrating its commitment to protect the right to engage in collective bargaining and to ensure equity for both labor and management. A company unwilling to use unlawful tactics ought not to be put in a competitive disadvantage of the employer who will. These cases also illustrate a significant difference between the administrative law remedies and common law remedies, particularly in an employment context. Courts of general jurisdiction have tended to reduce all remedies to their, as we know, monetary equivalent, probably reflecting a desire to avoid having to monitor remedies and the fact that most cases before the courts do not involve an ongoing relationship between litigants. The contest is essentially over a historical problem, past damage. Labor boards, on the other hand, were established in part to provide more effective regulation and relief to ongoing relationships. Recent cases demonstrate the OLRB's interest in providing a range of remedies that bear greater relevance to the real impact of unfair labor practices. But the downside for us in making certification applications is in making certification applications and related unfair labor practice complaints more complex, more slow, and requiring the involvement of more professionals. However, our labor relations officers have continued to provide outstanding service to our clients, as those statistics that I recited to you reveal. And we remain of the view that more effective remedies can also mean less litigation, as respondents come to realize their potential downside in a possible loss before the OLRB. On the negotiation front, again, I'd give you quickly and briefly, and I'll say briefly a few more times just to keep your attention, some statistics. In Ontario in 77-78, and I went back that far only because I didn't have more recent data, not that I was trying to be selective, although I would if I could. The Labor Board handled 563 non-construction industry applications for certification. Of the 563, 423 units obtained bargaining rights. Of the 423 bargaining units, 315 collective agreements were negotiated. Okay, so you see the fall off. No labor relations statute guarantees employees a collective bargaining agreement, and all statutes provide for the resolution of bargaining impasses on the basis of relative bargaining power, the freedom of contract policy that I talked about at the outset. Accordingly, the failure of a trade union to reach a collective agreement may simply be the product of unreasonable demands, but it may also be the product of ongoing employer opposition to union recognition and a desire not to have a collective agreement. We're in a first contract context. How are we to determine? We have seen a number of recent developments designed to deal with first agreement labor relations conflict. Where the conflict has been the product of unlawful employer interference, the Labor Board has fashioned a number of remedies that I've discussed earlier designed to rectify the situation in real labor relations terms. But in deference to the freedom of contract policy underlying the statute, the Board has steadfastly refused to impose a collective agreement. Whether this approach, the awarding of monetary relief to employees and at times, together with many of the other remedies already discussed, will be more successful than first agreement arbitration adopted by a number of other jurisdictions is too early to tell. In this area, in any event, Ontario has adopted a remedial policy that tries to be more sensitive to the freedom of contract goal underpinning the statute. The Board has also cautioned trade unions against running to the Board in an attempt to supplement their bargaining power. And I refer you to Goldcraft, and I refer you to comments in both the Radio Shack and in Photomat, and indicated its reluctance in these same cases to intervene at all in established bargaining relationships where there is much less risk that the union recognition is the source of the parties' problems. And a good example of the Board's reluctance to get into anything would be the Canada Cement Lafarge case, where the trade union was asking for us to censure various communications directed to employees just prior to a last offer vote. Bill 89, passed in June of 1980, provided for compulsory dues checkoff, but it also, as I just hinted at, provided for a last offer vote procedure where an employer can ask that his last offer be put to the employees, really go around the bargaining agent on the theory, the statutory theory being that the bargaining agent may be out of tune, out of touch with the majority wishes of the employees. And recently, and I refer you to Canada Cement Lafarge, in November of 1980, the Board concluded that a positive or an affirmative vote in favor of that last offer results in a binding contract in effect, and we directed the trade union to prepare and execute a collective agreement. So Section 14, clearly, with respect to remedial powers, works both ways. And I think those kinds of decisions really do demonstrate how penetrating third-party intervention in the collective bargaining process has become. The administration of the collective agreement, and this is where I come to conclude my comments, I simply direct your attention to Section 37A, where now a trade union or an employer can opt for a statutory form of grievance arbitration, notwithstanding what's in their collective agreement. And if they do, they get a hearing within 30 days, and it's probably a little cheaper than typically in the private sector. I'm told that there have been 311 of these applications since 1979. I don't think that's a terrific amount. But as I understood the theory of that amendment, It was that the system lacked case management or a body responsible for the overall efficiency of grievance arbitration in the private sector, and the government then stepped in. Another labor board development in this area would be the Valdi case. I refer you to Valdi, where the board refines and develops its theory of deference to grievance arbitration. And you ought to be aware that in the construction industry, we are significant grievance arbitrators. We would do probably most of the grievance arbitration work that's done in the construction industry under 112A. And it's interesting, an employer in the construction industry is certified without a hearing. He immediately becomes subject to a provincial agreement without any further negotiations. And should he fail to honor the agreement, the board must hear the resulting grievance within 14 days of its filing. That, ladies and gentlemen, is modern conflict management, or a terrific amount of political power to have that kind of legislation passed. But I think fairly it represents the kind of treatment the construction industry has been getting from 1960. The legislature has increasingly recognized that it is different, and it has to have a statute designed substantially different. And we see this in a number of other fields, such as teacher and school board bargaining, etc. There's many other developments in the contract administration area, and I won't take up your time. In conclusion, legislatures and labor boards must continually evaluate and reevaluate substantive, procedural, and remedial rules to ensure that they have served their intended purpose of effectuating the practice and procedure of collective bargaining. The mid-1970s saw significant new responsibilities accorded to labor boards as legislatures began to concern themselves more and more with the quality of the labor relations legislation that had been in place for over a quarter of a century. Since the passage of these provisions, there has been a continual unfolding of new labor board responses to meet the needs of individual situations, and there has continued to be more surgical legislative change aimed at facilitating collective bargaining and ensuring industrial peace. On the other hand, the intrusion of these new remedies and substantive rights do not seem to have increased the relative extent of collective bargaining in this country, but they certainly will increase the extent of legalism, and they have the potential for undermining the initiative of the parties. A system that is intervention-prone can corrode the willingness of parties to provide their own solutions to problems. While some commentators have characterized these recent developments as labor legislation entering the jet age, others might wonder about the wisdom of this stance in an era of fuel scarcity. Unfortunately, the parties have left the impression that they are all too often incapable or unwilling of greater cooperation without third-party intervention. What must concern all of us in this country today, then, is the increasing evidence that the collective bargaining process is sadly out of tune with the widespread cooperation and initiative required by our ailing economy. On the positive side, however, there is evidence of a growing need for you and me. I wish you a very instructive day. Thank you.